So clients often ask, you know, do they need to be concerned about somebody challenging their will or their trust? And the answer to that question is it depends on a lot of different things. So for one, when a client has that concern, and in particular, if they can name the person they're concerned about, we oftentimes will prepare what we call an in terrorem clause. And what an in terrorem clause says that if this will is challenged, that the person who you've left money for that challenged the will gets zero. And so usually that's quite a disincentive to challenge. But let's talk about what are the reasons why the causes of actions that somebody could challenge. They could challenge a will because maybe the testator or the writer of the will was incapacitated. They might argue they were under duress. They might argue they were coerced. More often than not, those issues plainly don't exist. But there are people who come in who are elderly, and you know, a lot of times we have to exercise judgment here in this office, you know, whether or not the person who's bringing them in might be the person who is you know, using undue influence. And so we try to act with discretion to make sure that we're giving the clients the good advice. And you know, we like to think of ourselves as we're representing the good guys, and it can be a tricky issue. But for most people that are doing it, they're really, you know, if they're at full capacity, full mental capacity, it's just not an issue for that their will could possibly be challenged, or successfully challenged, I might add. Thanks for listening, and we would love to help you. And if you have questions about the services that we provide or a specific question, feel free to reach out to us. You can find all of our contact information on our website, and we look forward to seeing you.